Great. Hi, everyone, and thank you for joining us for today's webinar, Data Mapping DPOs and Consumer Protection, Creating a Winning Approach for Global Compliance. So we have a great presentation lined up for you today. So I just wanted to go over a couple of reminders before we begin. This session is being recorded and it will be available on demand at the conclusion of the presentation. A copy of the slides will also be made available. Lastly, we'll also have time for questions at the end, so please feel free to submit questions at any time throughout the presentation in the Q&A box. So before I hand it over to our three great presenters today, a quick disclaimer. The opinions discussed in today's presentation are those of the individual and do not represent the firms, companies, entities that they may be affiliated with, nor are they necessarily customers of Active Navigation, HewardMills, or Faegre. And that's it. Now I am going to hand it over to Peter Baumann, CEO of Active Navigation. So over to you, Peter.
Thank you very much, Neve. Hello, everybody. My name is Peter Baumann. I'm the CEO and the co-founder of company Active Navigation. I'm based just outside of Washington, DC, actually in Virginia, but not far from DC. Active Navigation is effectively an information governance company. We provide expert solutions in the areas of data discovery, data mapping, data classification. Our world kind of changed over the last 3-4 years as the data privacy regulations and the coming of cyber and privacy, or the coalition of the two, really took place. And most of our world is now spent doing data mapping for privacy data, PII, sensitive information, and data minimization. We work for more than 300 different companies in more than 30 countries around the world. I'm delighted actually to kind of be joined today by two indisputable experts in the world of data privacy. I don't know if they're on the slide there. You can see we have Dyann Heward-Mills. Dyann's name's actually on her company door, HewardMills. Dyann set up a outsourced DPO, data protection officer company, just over a couple of years ago. It's had phenomenal growth over the first 2 years or so. And Dyann is definitely a global expert in the world of data privacy. Some of you may have already seen Dyann. She's well known on the lecture circuit. She's also been appointed as the ethics expert for the European Commission in research and innovation. Prior to setting up her own business, Dyann was the global partner at Baker McKenzie, leading their data protection and cyber security practice, based in London. Prior to that, she was the senior privacy counsel at GE Capital and a senior privacy and communications lawyer at Linklaters. I'm also joined by Catherine Armstrong. Catherine, like me, is based in DC, Washington, DC, here in the States. She's counsel at Faegre. And Catherine's got a fantastic career as well. She spent the bulk of it working at the FTC, that's the Federal Trade Commission, where she did a lot of work on granular matters around policy, covering all aspects of consumer policy, security, state security laws. Catherine supports all her clients primarily in giving them guidance around compliance issues for a broad range of the different privacy regulations, including CCPA, GDPR, New York cyber regulations, and other which we'll get to. Interestingly, Catherine's also taken of late the responsibility within her own organization for the deployment of the CCPA rules and regulations. I guess, Catherine, in a way that makes you both a preacher and a practitioner for our audience today, which is quite unique, I think, sometimes. That's great. Thank you both for joining me.
Thank you.
Just a recap of the agenda today. We're going to be talking a little bit about a refresh for some of you, otherwise hopefully some new news as well, around the rise of global data privacy laws to help set the scene, the role of data mapping and data protection officers within that area, how to operationalize a global privacy program, and then ultimately actionable strategies for achieving continued compliance. And hopefully, if we have time at the end, room for some live Q&A as well. So just if I kick off with a bit of a refresh, if you like, on global privacy laws, and really why we're all here today. There's a lot of data out there. There's that's it. There's a lot of data out there. You'll be familiar with many of the reports. But essentially, the problem at its root level is that organizations, whether they be in the commercial enterprise or government, federal, local government space, don't know what data they have. They don't know what they have, why they have it, where it is, who owns it, and not least how much they have. And this is a problem that we in our travels experience just about every organization. PwC recently ran a report that actually showed that 51% of the private sector didn't have, or half the private sector didn't have an accurate inventory or data map of their personal data for employees and or consumers, didn't know where it was stored and how it was collected. Our own experience is that's probably quite a low estimate, and we think it's more like 80% that probably don't actually know where their data is and how it's collected. And then another recent reports are carried out by the Chartered Certified Accountants, more than 1,500 CFOs and finance leaders, showed that 57% of them said cyber security was a top 5 business risk. And this is interesting. This is the coming together of cyber and privacy, which we're going to see more and more of. And 1/3 of those respondents didn't know if their company had even suffered cyber attacks. That's a really, really scary thought. 20% of them had no involvement in cybersecurity, even scarier thought. One of the data stats we don't have on this slide, which I always find very helpful, as do our customers, provided by the Poneman Institute, if you're familiar with it. And there they've done research which shows that the average hack, so when the intruder is in your network, it takes the organization at least 300 days before they discover they've been hacked. So the bad intruder, malicious intruder, has more than 300 days at will in your network to find the data that they're interested in. It's a scary prospect. Many of you will be familiar with the various data privacy laws, either already in effect or coming through. So this is just a little bit of a recap, a refresh, if you like. Currently, there's more than 120 major jurisdictions that either passed or proposing passing privacy regulations. 120, that's accelerated from a standing start just a few years back. Of course, it was the advent of GDPR back in May 2018 that kind of set off this new race era to data privacy, if you like. And everyone's been either playing catch up or follow my leader. But no matter where you have your HQ, your headquarters, privacy laws are a growing operational challenge. All organizations are struggling with these. The Brazilian implementation has been delayed, despite it being shown here as May 2019, and they're expecting that to come through for May 21. The GDPR rules themselves have been complemented by an EU e-privacy regulation, which looks to include other communications data, such as cookies, similar technologies, metadata, that's called attributes that are caught as part of the discovery process. Much wrangling, diverse positions on legitimate interest grounds continues, but these things will be coming through. We've seen that. The Swiss data protection law expected to be finalized in September 2020 and implemented from January 2022. There's a lot of activity. If we start by maybe going back to GDPR, and as we have one of our resident experts, I'm going to pass to you, if that's okay, Dyann.
Sure. I mean, I think the landscape that you just walked through there is very sort of insightful, isn't it, in terms of evolving requirements globally. And I think actually the GDPR sort of set the standard, and many organizations that operate across Europe and globally look to implement a sort of a robust GDPR standard with the expectation that if they have got a strong GDPR program, actually they can meet requirements in many other jurisdictions and also evolving requirements. I think the intention of the GDPR was obviously to harmonize laws across Europe, and ensuring the sort of the protection of the sort of fundamental rights for individuals, enhancing those rights. Clearly, the new levels of transparency around data collection, storage, and usage that has now become the expectation of individuals, the expectation of regulators, the expectation of stakeholders. And I think what this is really driving within organizations is this requirement to be accountable, and senior level accountability in particular. So it is an issue for the board, it is an issue for the C-suite, it is an issue for every individual within the organization, actually, where they are handling vast quantities of data or involved in processing of special categories of sensitive data, or developing innovative technologies or processes where individuals' personal data can be potentially exposed or compromised. And actually, there are lots of areas where this might arise. So we've mentioned a few here, just from basic identity information, just a name, address, employee number. All of those categories of data would be caught. And then also some less obvious, like IP addresses, or perhaps where there is cookie data being used in innovative and other technologies being used in ways that capture data that wouldn't immediately be assumed to be personal data, but do actually identify individuals. To very sensitive areas where, for example, biometric data is being used, or data that can be used to racially profile individuals. Obviously, very, very sensitive in the current climate. And I know there have been a number of organizations that have actually halted development of certain technologies that can be used to discriminate against individuals.
Yeah, just on that point, you talk about the current environment. I assume you're referring to COVID, the pandemic, and that it's brought a greater awareness to some of the kind of technologies that people are looking to implement in order to protect us from the virus, but have knock-on impact and consequences around data privacy. Is that correct?
I mean, absolutely. COVID is definitely an example where there are emerging technologies, and actually the key issue is around whether individuals trust those technologies sufficiently, whether there has been sufficient transparency about the purpose to which data is going to be used when collected, and not just COVID, also obviously in relation to Black Lives Matters and the use of facial recognition as well, and the profiling of individuals in that context. So a number of different areas where actually these issues have now bubbled to the surface, and organizations are having to think very carefully about the use of certain technologies and how, whether perhaps inadvertently, those technologies could be used to discriminate in one way or another.
Yeah, it sounds like we're moving into a new era, aren't we? The irony of things to protect the population versus their privacy, and the needs to protect their privacy going forward. No, that's very helpful. Thank you. And again, Dyann, maybe you could just talk to some of the data subject rights here.
Absolutely. So I guess, we've sort of talked at a sort of macro level of the GDPR, this need for accountability, and also some of the data that potentially requires sort of special attention and protection in terms of how those rights are indeed protected. So I don't know whether you might want to go to the next slide, Peter, the data subject rights. Sorry, I think we've skipped ahead. Yeah.
I am on excellent. That slide. I don't know if it work. Yeah.
Okay. So the variety of rights as set out in the GDPR. So there's sort of the right to be informed. I think one that is particularly exercised by individuals is the right of access. So the right to know what information is held about them by an organization and the purpose to which that information is being put. This right, when exercised, actually can be very operationally disruptive if organizations don't have a handle on what personal data they keep, where it's kept, and easy accessibility to that information if requested. Increasingly, what we're seeing is organizations almost allowing individuals to operate almost like a self-service type approach when it comes to rights, whether it's employees or customers, being proactively transparent and allowing individuals themselves to access data directly. Other rights include the right to rectify information, the right to erase data where its use is expired, the right to restrict certain processing, in particular in relation to marketing. Interesting right, the right of data portability. So if you are have provided your data in a context that's being used, for example, on a platform, and you want to move from one platform to another, how can you exercise that right? Operationally, how does that happen? And there are other restraints in that. So it's not an absolute right. There may be certain intellectual property considerations where it comes to the right of portability. So I think the full scope of that right and how it's operationalized is yet to be fully explored. But ultimately, what all these rights point to is enhanced position for individuals to actually understand what organizations are doing with their information and to control that to some extent. And say it's not always absolute, so there may be other grounds where information about individuals can be held by organizations and processed legitimately. There may be lawful reasons why organizations can continue to process data. But the whole sort of ethos of provisions like the GDPR is to enhance the rights of individuals and to allow them to exercise those rights in this way.
That's fantastic. Thank you very much, Dyann. And so maybe we turn our attention to the United States. Catherine, we obviously don't have any kind of comprehensive overarching policies such as GDPR at the moment in the States. Can you talk to the kind of fragmented nature of the US and where you think that's moving, please?
Yes, thanks, Peter. Absolutely. Well, Dyann was absolutely correct that accountability is key for corporations, businesses, government, anybody. But the reality in the U.S., as Peter noted, is that there is no overarching privacy law. In other words, but there are a lot of segmented laws that deal with specific types of data. There are also different federal agencies in the U.S. These are some pictures of the seals of those federal agencies, all of whom have a role in enforcing some kinds of privacy law. So the fact that there is no comprehensive law in the U.S. means that unless it's prohibited, it's allowed, which is a completely different paradigm than Europe. So it's essential that companies understand what data they have in order to determine which of the alphabet soup of federal laws apply to them. There's the Fair Credit Reporting Act that deals with consumer report information. There's HIPAA, which deals with covered entities and certain health information. There's the Children's Online Privacy Protection Act that deals with children under the age of 13. There is the Gramm-Leach-Bliley Act that deals with financial institutions and customer data. So the reality of enforcing and then there's the FERPA, which is the federal education privacy law that deals with schools that have information about their students. The Federal Trade Commission, my former agency, enforces Section 5 of the FTC Act, which prohibits unfair or deceptive acts or practices. And for the last 20 years, the FTC has brought over 100 privacy and data security cases. We might talk about a few further on under that authority. So an example of a deception case would be a company that makes a representation in their privacy policy that they either A, protect your privacy or protect your personal data from cybersecurity, or they have good data security, when in fact they don't. As I mentioned, the FTC has brought over 50 cases in the last 20 years. Certain things I'll give you one of my favorite FTC actions that involve deception and privacy. A particular flashlight app company failed, well, they said, we protect your data. They, in fact, downloaded people's contact information from their phone. And the commission found that to be, actually, that was an unfair practice. Other deceptive practices have been misrepresentations in privacy policies. So it's very fragmented at the U.S., at the federal level, and as the next slide will show, it's fragmented at the state level too. This year, and specifically beginning on January 1st, and then again July 1st this year, the California Consumer Privacy Act became effective January 1st, and the AG began enforcing it July 1st, although there have yet to be any enforcement action. So there is the federal things we just spoke about, and now there is state laws. In addition to the California Consumer Privacy Act, which is top of mind, there are 50 separate state breach notification laws, which means that when you have a cybersecurity incident, you have to figure out what state requires you to do what. So that's another patchwork. There are also likely to be more state laws like the California Consumer Privacy Act. Before the COVID crisis, there were at least 13 states that had bills that looked just like the CCPA. So there's tension in the U.S. at regulation at the state level and the federal level. The Federal Trade Commission, again, my former agency, has for the first time recommended that there be federal legislation because it is extremely onerous, as you can imagine, for businesses to figure out what law applies to what type of data they have. And as the next slide shows, it's even more complicated because the remedies change. Not every privacy law violation, there are different remedies, different requirements. Sometimes there's monetary relief. Sometimes there's the restriction of or loss of government funding. That primarily happens in the education space, the FERPA law that I talked about. There's, the injunctive relief, notification of consumers, a requirement that one of the things the FTC does when it brings an action is to require that a company develop and maintain a comprehensive privacy and data security program. Sometimes companies have to delete data. So we now have 3 dishes swirling in the air that companies have to consider. Let me spend just a moment talking about the California Consumer Privacy Act because a lot of people compare it to the GDPR. It really is very different from the GDPR in terms of what its requirements are. The GDPR was a more thoughtful and well-conceived law. The California Consumer Privacy Act was written very quickly. It was originally a ballot initiative, but in order to take it off the ballot, the California legislature very quickly created the CCPA so that they might have some ability to amend it over time. Spoiler alert, there's likely to be another ballot initiative in California in November that goes a little bit deeper and touches on some GDPR-esque type activities, such as dealing specifically with sensitive information. But at the same time, even though it's a different kind of law, its implicit requirements are the same as GDPR in that companies need to know what data they have, where it is, who has access to it. Because the CCPA does give California consumers the right to request access to their data, the specific pieces of data they have, the right to request that data be deleted, and the right to request that their data not be sold. But these are not absolute rights because there are exceptions to everything. And perhaps we'll have the opportunity to dig into that a bit deeper later.
Catherine, thank you very much. Just before I move on to the next slide, maybe a question to both of you. It's an incredibly complex regulatory environment, and if you're a business that operates across many different legal jurisdictions, including different states maybe in the US, how do organizations kind of get to grips with this? And given our conversation today, we're talking about, data mapping. Is data the right granular level to try and deal or one of the items you need to use to try and deal and address these regardless of the jurisdiction you're operating in?
Let me jump in first. I think in the US, you first have to figure out what data you have. Is it health information, which HIPAA applies? Is it financial information, which Gramm-Leach-Bliley may apply? Is it involving children under the age of 13? In California, what's so different is that they have defined personal information extremely broadly to include IP addresses, cookies, pixels, things like that. So to come to grips with what you have, you need to understand what you have to do. You need to know what you have. I think an interesting exercise for access is you should pretend that the New York Times or the Daily Mail is making an access request of someone's personal data. What is that report going to look like? And would you want that splashed in the newspaper? To Peter's earlier point, most companies don't even know what they have. And some of the most provocative data companies have is inference data about their customers that they purchase from data brokers in order to market to them in a more targeted fashion.
It's helpful. Dyann, is there anything you'd like to add to that?
Yeah, absolutely. I wholeheartedly agree. Like, you can't start to build a robust compliance program without actually having an understanding at a very granular level of the information that you have. So I know there are times where organizations might start to look at the systems in which information sits and to map out those systems, but you really need to have an understanding of the data within the systems, and not only an understanding of the data, but actually who are the custodians, who have responsibility for ensuring that that data is maintained in an appropriate way, is deleted in an appropriate way, is used in an appropriate way. So you really do need to have that sort of granular level of insight in your data, and in particular your data flows as well within an organization.
Yeah, no, that's very helpful, because it is a bit of an overwhelming challenge, isn't it? And so, Dyann, probably if I turn to you here, data protection officers and DPOs, from my understanding, my travels, this has originated from GDPR. If you could just talk to a little bit, refresh us where you believe the DPO sits at the moment and requirements.
Absolutely, I'm very happy to do that. So, of course, I run a global outsourced DPO service, and I very passionately believe in the importance of DPOs in helping organizations to demonstrate that accountability. And actually, to do that effectively, there are a number of key things I think that a DPO requires, and fundamentally, a DPO must be independent and be allowed to operate in an independent way. So it's important to recognize that a DPO is performing a statutory role for those organizations that appoint a data protection officer. And there are certain organizations that will be mandated to appoint a data protection officer. So if you are monitoring individuals systematically, you will have an obligation to appoint a data protection officer. If you are processing special categories of data, we talked through some of those categories in relation to health, political opinion, biometric data. If you're doing so on a large scale, again, you'll be required to appoint a DPO. And I think it's really important to also understand, because of the independent requirements, that a DPO is not a chief privacy officer. I think they perform very distinct roles. And Catherine, I'm sure you've got some views on that as well.
In fact, they can't be one and the same statutorily, right?
Yeah, they're looking at the issue of data from a very different perspective, and I think there's been a lot of confusion around that. Individuals sort of double hatting, and actually, it's really important that a DPO is not making the decisions on data processing. And actually, if you're in the role of a CPO or a CISO or a CTO or a GPO, you are the body that's actually making decisions, strategic decisions on data. You can't be doing that and mark your own homework as a DPO. That's where a clear conflict arises. Actually, there's only perhaps a very limited situation where a CEO can be a DPO, and that's where you appoint someone like me, as your data protection officer, because, I can make those decisions independently, and I'm not, in any way compromised in the way in which I advise you as a DPO. So, in all other circumstances, it's an absolute no-no. And, unfortunately, we do still come across scenarios and situations where individuals working in the business in other capacities actually making decisions around data in the business are also double hatting as DPOs. It's really important that your DPO has the relevant qualifications, and especially if you are an organization that's involved in high-risk data processing. An individual within our organization had a very good analogy, I thought. They said, you cannot be a player and a referee and a coach in the same game, right? So you've got to really understand the roles that individuals are playing. And when you think about the responsibilities that the DPO has, so, you are required to monitor the compliance of data protection laws by the organizations that you are engaged with. You provide advice on data protection requirements, such as conducting data protection impact assessments. And again, this is what drives the accountability within an organization. If you're engaged in a processing activity involving data that potentially exposes individuals to risk, you have to document that, document the risk assessment, and document how you're mitigating those risks. And a DPO independently have a role of reviewing that, challenging it, maybe supporting the position that you've arrived at, but they have to do all of those things from an independent perspective. Records of processing activities. We talked about, having a granular understanding of what data you hold in your organization. Well, there is a statutory requirement to record that information and document exactly where it sits, which third parties potentially have access to it, any assessments that you've conducted over that information. And also DPOs are very involved where there is a security incident or a breach within an organization. They often act as the interface between the organization and the supervisory authority, and will opine and give a view on whether they consider the assessment in terms of whether the incident has reached a level where it needs to be reported. They would have a view and actually provide their DPO opinion on those sorts of issues, including other sort of more proactive, wide range of activities, such as training employees, conducting audits, and proactively being engaged where there is high-risk activity to provide a view.
Yeah, Dyann, I just want to move on actually. So it sounds like DPO kind of space is a growth sector, and supporting that. I saw a recent study by the IAPP that they believe that we're going to need to hire up to 75,000 DPOs to kind of cover the kind of organizational requirements across. I don't know if that's EU-wide or if that's globally, but that's that's a lot of DPOs.
Yeah, absolutely. And I think very, very necessary too. You know, when I think of the value that we add to organizations, I think for those that are sort of invested in doing the right thing and building the trust of, their consumers, the stakeholders, their employees, and being very progressive on the issue of privacy and security, would value that role and ensure all those necessary requirements, as I mentioned, around independence, around ensuring that the DPO has sufficient resources to do their role, and also ensuring that they respect the views of their DPOs. And yeah, I mean, I think it is definitely a growth area, and it's very just interesting. Some of the enforcement action that's happened in relation to DPO. So we have the example there of the Hamburg commissioner issuing a fine for an organization that hadn't notified the supervisory authority of its DPO. So I think these are one of the sort of fundamental corporate governance steps that organizations need to take, is where you, especially in particular, where you have a mandatory obligation to appoint a DPO, and you have appointed a DPO, you must ensure that you've registered that DPO across the supervisory authorities where there is a requirement to do so. And to the point around independence, there was a fine by the Belgian DPA for an organisation who had appointed its head of compliance and risk and audit as a DPO. Again, we mentioned some of those roles, senior roles, that are also operational and not sufficiently independent. It's really important for organizations to consider the type of processing that they're engaged in and where that DPO function or individual should sit.
Yeah. So this is on the U.S. Let me just insert here that there is no DPO requirement in any U.S. law, even though, again, it's sort of a good idea and a best practice. Many of the FTC's enforcement actions have required that someone in the organization be accountable and report to the board. The New York Department of Financial Services cyber regulations, which we have not talked about, and they're sort of more cyber than privacy, but it does require the appointment of a person who is accountable to the board. Certain draft pieces of legislation, federal legislation, require that kind of accountability, although none of those bills have passed. So I think in the U.S. it's really important to take a lesson from the DPOs and GDPR in terms of conceptually building as a best practice that into your organization. In other words, someone who is not mixing the soup, but can do can analyze it at a higher level, more like the ref, as opposed to the coach. I just wanted to insert that.
Yeah, and I think that's very helpful. And if you could just go back one slide, actually, I think all of us will be familiar with the headline fines and penalties GDPR imposes, the 20 million euros, the 2-4% kind of bans. Me personally, until this discussion, I wasn't so aware of the risks, if you like, of getting it wrong with just the engagement of DPO. And I don't know, Dyann, if you have an idea of how prevalent this is. Are these the only 3 examples, or are we sitting on hundreds and potentially thousands of these? I imagine it's an area that organizations can easily slip up on.
Absolutely. I mean, the last example, which I hadn't had an opportunity to talk through, was the organization that was fined for not appointing a DPO. And that's an interesting example of the Spanish DPA actually taking proactive steps to review organizations that have a mandatory obligation to appoint a DPO. And it's a very easy thing to do, right? Because the sectors where DPOs will be mandatory. If you're in financial services or you're in the health sector, you're processing data of children, it's very easy to look to see whether you have appointed a DPO, whether they're named in your privacy notice, or indeed whether you've registered the DPO at the relevant supervisory authority. And yes, and we've had examples where organizations have come to us because they've had a breach or a complaint, and they've looked at their DPO provision and they've realized that actually it's not sufficiently robust and are wanting to take steps to ensure that they are meeting their obligations when it comes to the appointment of a DPO.
I think that's fascinating. The fines may be at a lower level, but the volume could be significant. And maybe it's only just got moving. Neve, if you could move to the next slide, please. And so, again, a quote here from Lee Matheson of the IAPP. Without good data mapping and inventory, no business can hope to accurately make the category-centric disclosures emphasised by the statute, let alone comply with verified requests from consumers, subject matter, etc., DSTARs. And so we're very familiar, for those of you familiar with some of the articles within GDPR, this sits quite squarely under Article 30. Catherine, a question to you, and maybe specifically CCPA. The equivalent isn't written out in such clear language, is it? How would you respond to that?
So you're absolutely right. The requirements in the CCPA, as I alluded to earlier, are very thin compared to the requirements of the GDPR in terms of structure of the organization and responsible people. But the requirements, I mean, the ability to comply depends upon exactly what we're talking about, which is understanding the data that you do have and perhaps engaging in some proactive data hygiene efforts on a regular basis. When I was a lawyer at the Federal Trade Commission, I'm old enough that my investigations involved companies that sent me paper. At the end of the investigation, or when I had closed the investigation or brought the case, I would get rid of the paper because these boxes were taking up a lot of room in my office. And once it ended, a Freedom of Information Act request could come in, and I didn't want anybody going through my files. So I would get rid of the stuff. Now, everything is on our computers. We don't get paper, we get files. Our IT departments are so nice that they give us more room, and we don't even know what we have until something happens and we need to start looking.
So the fact it's not called out in such explicit language isn't an excuse to act and ultimately go to granular level as well. That's helpful, Catherine. Next slide, please, Neve. I think it's back to yourself, Dyann, on protecting consumer data, DPO's kind of perspective on that.
Absolutely, and you know, I like this analogy that the DPO just needs to have a bird's eye view of data processing, and actually a good place to start is on the record processing activity, because that does give you that sort of overview of data processing within an organization, and in particular for DPOs that have responsibility across multiple jurisdictions and regions. It's really important to understand, you know, the definitions within in certain contexts, as Catherine was mentioning, and these can vary. You know, personal data is not the same as PII as the US would describe it, and understanding those nuances, I think, is really important. It's really difficult to do that at scale, and you really do need to have the engagement of different functions. You know, it's a cross-functional activity. It cannot just sit with, you know, a privacy office or indeed a DPO. It will need the engagement of your IT team, the engagement of your compliance team, your HR team, and legal other functions too. And, you know, it's something that needs to be kept evergreen. You know, it's not a one-off exercise. You do need to continuously prune and ensure that you have got that complete view and it's being well maintained.
That's great. Thanks, Dyann. Neve, we can move on to the next slide, please. So this title kind of concerned me a little bit. Living in the US at the moment with our current political masters, there's an argument out there which says that the problem is we've got too much COVID testing, which results in more positive results. I was a little worried that there was a parallel with this title. That's not the intention. I think what we're saying here is that your organisation is at more risk of being non-compliant because of the increase in regulations. So, Catherine, maybe to you. That's your understanding of this, correct?
That's absolutely right. Because in the U.S. in particular, there are so many different regulations that can impact or laws in different states, different federal agencies. It's sometimes hard to keep track of what your compliance obligations are, which is generally why we counsel clients to take sort of a more holistic approach to understanding their data and engaging in best practices that may go beyond what is required by a narrow law.
Yeah, no, I'm with you. If you could move on again, please, Neve. So this is a nice quote from the New York Times. Wake-up call, I think, for all of us. There's only two types of companies. Replace that with organizations. Those that have been breached and those that don't know they've been breached. That's certainly the experience we're encountering in our travels in the market as well. So big wake-up. In 2016, businesses saw a massive, nearly 600% increase in compromised records. More than 50% of those were due down to either malicious employees or accidental errors by employees. So this isn't something that's going to go away. It's growing fast, needs to be dealt with. I'm quite interested to hear, Catherine, with the definition of breaches, particularly across the different jurisdictions.
So just as a quick reminder, there is no federal breach notification law in the U.S., and there are 50 separate state breach notification laws. That means now there are a lot of similarities among the laws, but they define breach differently. Sometimes it's unauthorized acquisition. Sometimes it's unauthorized access. Sometimes it's both unauthorized access and acquisition. There are a number of safe harbors, like certain encrypted data might not, if it's compromised, may not be a breach unless the key is also released. And so once you've even figured out if your incident becomes a breach, you then have the jigsaw puzzle of what are the separate requirements, because some states require notification of the Attorney General for one consumer, others have threshold of 1,000 consumers. California requires a public notice, so it's just a jigsaw puzzle, and it's interesting, but it's not a fun process for an organization.
It doesn't sound like one, no. Understatements. Neve, you go to the next slide, please. Dyann and Catherine, we won't go through these. The audience will be very familiar with the levels. But my question to you, both of you, is I think particularly when GDPR first came out, was enforced back in May 18, we believed there would be more fines. What's your view on that? Is that a fair statement? And do you think we have the calm before the storm still? And we're waiting maybe now for the CCPA to drive the kind of approach to fining organisations?
So I think it's a very interesting issue, this one, because for those organisations waiting for the fines to do the right thing, I just do really think the approach to this issue from, in my view, a completely wrong perspective. I think good compliance and wanting to do the right thing is going to drive growth, right? Because individuals will trust the organizations that have robust systems in place and that respect their data and treat their information with dignity. So I don't think that fines should drive behavior. In terms of the levels of fines and whether that's the right levels at the moment, I do think that it's a new concept and there needs to be coordination across Europe. I think there are some regulators who are facing, large organizations with armies of lawyers and resources. And so they need to be very, very careful in their approach to finding an organization. They will be subject to challenge, quite rightly, actually, because the approach needs to be robust and the fines need to be proportionate and well thought through. So that will take time, inevitably, to build. And I think it would just be interesting to see how regulators use some of the other enforcement mechanisms at their disposal, such as information notices, audits, asking to see logs of within organizations, which they're entitled to do, and they do ask for those requests. And they're not going to make the headlines, but they can actually be very operationally disruptive. And also, the focus on issues such as DPOs and how independent your DPO is, the resources that you've provided to your DPOs. Those are very effective ways of ensuring governance and accountability. And I'm sure that there will be more fines inevitably also for those companies that's really acting in an egregious way and actually showing total disrespect for data and the rights of individuals.
Thank you.
So I was going to say, as a former regulator, where I enforced a law that allowed for the collection of civil penalties, figuring out what the right monetary relief for violations are is not science. It's very hard. I mean, the FTC has provided guidance in terms of the type of harm, the amount of consumer injury, the company's ability to pay, the reputation of the company, things like that. I will note that the Federal Trade Commission in the first instance is not statutorily authorized to seek monetary relief. And I'm sure everyone's heard of the FTC's action against Facebook, where they got $5 billion. That was because Facebook violated an earlier order, and under the statutory authority of the FTC, violations of an earlier order allow you to obtain civil penalties. So I just wanted to sort of throw out there that the calculation of what the right monetary remedy may be is difficult. But I also want to add, it can be significant and it can be painful, but I think it's the reputational harm of having a law enforcement action brought against you that is really important to consider. So I agree that monetary remedies should not be the deterrence because there's so much more at stake.
That's very helpful, Catherine. And Neve, go to the next slide, please. I think, and you've both alluded to this earlier as well. So it's really the loss of reputation. There's a number of drivers. There's the stick, there's the carrot. But it appears that the loss of reputation is clearly going to become one of the driving dynamics here in kind of the organizations seeking compliance to these privacy regulations. And if you could go to the next slide, please, Neve. And so this kind of brings us to the crux, if you like, of the discussion, which is how do organizations deal with this when they've got so many jurisdictions they operate in? Indeed, looking at the demographics of the attendees on this call, we have 44 countries. I think that might be the first time I've ever been on a call with 44 different countries. So welcome, everybody. I won't say that in your respective languages. But that's quite impressive, and it demonstrates a number of things, of course. It demonstrates the global requirement for data privacy. This is the big thing, but how it really does stretch around the world, and how if you're a global organization, you're going to have to deal with multiple jurisdictions and the challenges associated with that. And what we've tried to do through this discussion is show some of the tools and some of the thinking. And if you go to the next slide, please, again, Neve. So, clearly the ability to know what you've got and where it is, a data map, is not a nice to have. It's not for Christmas anymore. It's something that you need. You need it refreshed, you need it current, and you need it across all your data assets. Now, from our experience, the way that you're going to do that is with a combination of people, process, and technology. It reminds me of one of the leading analysts giving a talk years ago to a CIO audience, a few thousand CIOs indeed, in Orlando. Deb Logan, she was then the analyst for the discovery space, moving into information governance. And she said, look, people and technology got us in this mess, the data mess. Only people and technology can get you back out of it. But you need to add on the policy as well. And so to do that, your organizations need the best people. You need the subject matter experts, you need executive sponsorship, and you need the right teams put in place. That's the people. You're then going to need the correct policies. We've got 2 experts here on the call, but you're going to need your counsel, your CPOs, your DPOs, your inside and your outside counsel. You're going to have to get those policies in place, ensure that they're executable as well. And supporting those policies, you're going to have internal processes, methodologies, and alike. And then if you could go to the next slide, please, Neve, you're going to need technology. And it's quite a complicated landscape that you're looking at on the technology front. I'm not going to try and explain all this here, and you'll be going to your IT departments for their perspective of this as well. But you've got application tools that are going to span capabilities that include discovery, mapping, classification, through to access controls, who owns and who has rights to that data, and anonymization. That's before you hand the data off for encryption and other. You've got 4 or 5 classic categories at play in the space, sitting largely underneath IRM, which is Integrated Risk Management Platform, and you need the right tools that feed into that. Those 4 segments are CASB tools, DCAP, and DLP. DLP would be the one most of you would be familiar with, which is effectively tracking data in motion and security around data in motion. And finally, and I've called it out there, not least because that's what I do, what our company does, but file analysis. And file analysis is a relatively new player in the space of category, the label that Gartner's given it. But it's super important because it's the tool that gives you the granular approach to all those data assets you have out there. It largely deals with it from a metadata attributes, but the more sophisticated tools will look at file analytics, contextual analytics, etc., right through to ML and AI. With these tools in place, you have some means of controlling and getting to a data map. That's really, really important. It's a challenge. We've been doing it for years. It is hard work, and so you need to have the right tools and right people and right process obviously to support that. And I think without further ado, we're nearly on time, so I'm going to pass back to you, Neve, if that's okay.
Great, absolutely. So thank you to everybody. I think we have time for a couple of quick questions. So we've got one that says, to be clear, should a DPO always be independent of a firm's privacy office?
So I can take that. I think the independence of decision making is very important. So a DPO always needs to be acting without conflict. A DPO needs to work very closely with stakeholders within a business, including the privacy office. So I think the DPO should be close to the privacy office, and depending on the level of risk that the firm of data processing that the firm is engaged in, the more risky, the greater the level of independence, really, and the greater the responsibility of the firm to be able to demonstrate that the DPO was indeed an independent actor. The privacy office have a particular role that they play, which is different, from a DPO's role. So if anybody wants some further information on that, they can drop me a line, and I'll be very happy to explain how I see the two coexisting without conflict.
Great, fantastic. And then I think I have time for one more question just to make sure we can get to a contact information at the end. So that is, with the world going into a recession that may affect revenues for years to come, how are you encouraging organizations to better invest in data management that is maybe seen as a pure cost center, when they are most concerned about? So how do you address that risk?
So I would say that the regulators are still on doing their jobs. Even if the world is going into a recession, the law enforcers, the regulators are going to be looking for law violations. It may impact what a financial remedy may be, but the law enforcers are working.
Fantastic. Well,
if I can add from the cold face there, we've seen a number of engagements with customers that took a little bit of a pause at the point of COVID, and as they were changing business continuity, working from home. And then with a matter of days or weeks, they came back and said, you know, we still need to comply. We're either going to be in business or out of business. If we're in business, we have no choice. And so they may change the scope, they may change the timing, they may try and address budgets, but they don't stop. This doesn't go away.
And bad guys are really smart and understand when organizations are vulnerable.
Absolutely. So unfortunately, that is us at the top of the hour. So for all of the questions that we didn't get to today, we will follow up with everybody individually to get those answers to you. So I wanted to say thank you so much for your time, and thank you to our 3 great presenters. As a reminder, we will be following up with a copy of this recording along with a copy of the slide deck as well. And in that slide deck, we will also have a slide that has a tips for compliance along with the contact information for the presenters today, if you have any questions after you've reviewed the presentation. So thanks, everybody, and enjoy the rest of your day wherever you are.
Thank you.